As many of you know, I'm the district attorney for Colorado's 20th Judicial District, which is Boulder County. I'm here today to give a brief statement regarding the charges that were filed about an hour ago in the case of people of the state of Colorado versus Dynel Lane. I will discuss the legal basis for those charges, and I will answer a few questions regarding those matters only. You should know that for ethical reasons, I will not discuss the specific facts or evidence in this case other than as necessary to explain the charges. Nor will I discuss particulars regarding the victim because she has expressed a request for privacy at this time. The charges that my office filed about an hour ago, which we believe are supported by the law and the admissible evidence and can be proven in court beyond a reasonable doubt to a jury, are as follows. And there's 9 counts. I believe many of you have received a summary that lists those 9 counts. The first is criminal attempt to commit murder in the first degree. This is a Class 2 felony, and it has a possible sentence of up to 48 years in the Department of Corrections. The second is a crime of violence enhancer on that charge, which is tied to the use of a deadly weapon in the attempt to murder the victim in this case. The third is a crime of violence enhancer, which is also tied to the attempted first-degree murder charge related to the fact that serious bodily injury was inflicted in the course of attempting to murder the victim in this case. Count 4 is assault in the first degree. This is a Class 3 felony, alleges the use of a knife, and with a possible sentence of up to 32 years in the Colorado Department of Corrections. The 5th count is assault in the first degree, also alleging use of a knife, and it also is a Class 3 felony with a possible sentence of up to 32 years in the Colorado Department of Corrections. The 6th count is assault in the second degree, alleging the use of a deadly weapon, a bludgeon. It also has a possible sentence of up to 16 years in the Department of Corrections. The 7th count is assault in the second degree, alleging strangulation. It also has a possible sentence of up to 16 years in the Colorado Department of Corrections. Both of the second-degree assault counts are Class 4 felonies under Colorado law. And the 8th count is unlawful termination of a pregnancy in the first degree. It is a Class 3 felony with a possible sentence of up to 32 years. Now, there's a few things that are very important for me to say about these charges. First of all, let me stress that you have to remember that the defendant has only been charged with crimes. She has not been convicted in a court of law. She is presumed innocent unless and until she is found guilty by, beyond a reasonable doubt, by a jury of her peers. As with anyone accused of a crime in our justice system, she deserves a fair and impartial trial. Now, you should also know that prior to filing these charges, over the last several days, we've been working very, very hard. I've met several times with the Boulder County Coroner, Emma Hall. I've met several times with the victim, Michelle Wilkins, as well as her partner, Dan, and her parents and many other family members. I met with them as recently as this morning when I explained the charges to them that I would be filing this afternoon. Some of you know that from the coroner, who issued a press release a couple hours ago, I learned that the autopsy conducted by an expert pathologist, Dr. Leon Kelly, did not find any medical or physical evidence that the baby, Aurora, ever took a breath after being taken from her mother. In Dr. Kelly's opinion, this was not a live birth. According to Dr. Kelly, and I quote, "The autopsy and investigation failed to provide evidence that the child exhibited signs of life outside of the womb." Now, I know that it has been widely reported in the press, based on an initial police report from a statement taken from a witness immediately after the events of March 18th, that the witness observed Aurora taking a gasping breath. However, upon a more thorough examination of this witness by the Longmont Police Department, the witness clarified that Aurora was still and her mouth was open, but she was not breathing, which is consistent with the medical evidence from the autopsy, with Dr. Kelly's opinion, and with the other evidence in the case. We do not know the exact cause of death of Aurora, as there were no other injuries or other medical issue to explain it. However, test results are pending, and a final autopsy report will be issued by the Boulder County coroner in approximately 6 to 8 weeks. And after the victims and the victim's family have had a chance to talk to the coroner, that report will be made public. Now, Colorado criminal law, and we talked about this about a week ago, defines homicide as the killing of a person by another. And it defines a person, when referring to the victim of a homicide, as a human being who had been born and was alive at the time of the homicidal act. And this is set out explicitly in Colorado law in the statutes 18-3-101. Colorado law, under the case law interpreting this statute, further specifies in the cases People versus Lage, L-A-G-E, that person does not include a fetus, even if the child is born following the injury which ultimately results in its death. On this point, Colorado law is absolutely unambiguous. Now, I understand that many people in the community, and heaven knows I've heard from a lot of them, would like me to have filed homicide charges. However, that is not possible under Colorado law without proof of a live birth. A prosecutor cannot file murder charges when a baby who is killed has not lived outside the body of the mother. For similar reasons, I cannot bring charges of child abuse resulting in death. As district attorney, I have a sworn duty to uphold, to apply, and to enforce the law as it currently stands. District attorneys do not decide what the law is. They enforce the law as written, which of course is the essence of the principle of the rule of law, a fundamental principle on which our country and the state of Colorado were founded. I have a sworn ethical duty not to file criminal charges against anyone that are not supported by law in existence at the time and by the admissible evidence, regardless of my personal opinion of the law. As I said, I cannot comment specifically on the evidence or the facts of the case beyond what I've stated here. I will take a few questions. One thing I will mention before we do that, some of you I think were at the filing of charges, which was at the courtroom in the jail, which is, to say the least, a little crowded. That's why we're doing this here. There has been a preliminary hearing date, I said, I believe, right? The next court date in this case, which will be the preliminary hearing, will be on May 5th. That will be back in this building. Do we have a time for that? At 1:30. That's my statement. I can take a few questions. Yes.